Senate will come back to order. We're going to pick up debate on House Bill 605. The chair recognizes the senator from the 6th to speak to the measure.
Just start? All right. Thank you, Mr. President. So the hour is growing late, I know, and we have just had Italian food, so I think folks may be a little sleepy, but I think this is an important measure, and I think it deserves our attention. So let's go back to why this law, why this bill at this time. And as the senator from the 26th likes to say, what's going on? What's really going on here? So this bill is the product of a case that was decided by the Georgia Supreme Court that just came out in December of 2020, like the sponsor said, Knuckles versus State. In that case, an 80-year-old nursing home resident died of neglect. Unbeknownst to the nursing home or the workers, the family had placed a hidden camera in the resident's room for the purpose of determining if their father was being neglected, which is exactly what the family suspected. And for anyone who's ever used one of these devices, they are almost exclusively used when you suspect that a caregiver might be abusing or neglecting a vulnerable child or a senior adult. Hence the term we hear, nanny cams or granny cams. This 89-year-old elderly man was found unresponsive in his room by members of the nursing staff. But the nursing home workers, they didn't initiate CPR when they found him. And after it was clear that he was dead, they went about trying to hide their neglect of this poor man. They replaced a faulty oxygen canister. And then an hour after they discovered his body, the nursing home workers started to perform two-person CPR to create the false impression that they had tried to save his life. But they were not able to escape justice, nor was the nursing facility, because all of this was caught on video. Video that was used to hold the facility and its workers responsible for their actions. Now, I want to clarify something. Knuckles versus State is in fact a criminal case, but that's not how this started. And in fact, with respect to the family of the 89-year-old man, they went to the authorities. The authorities said to them, this is a civil matter. We're not going to get involved in this. They commenced a civil suit, and only after press started getting a hold of the video and things came out, the facts came out, then the authorities got involved and they charged the nursing staff from the facility. And so this case comes from that, because that nursing staff moved to throw out the video. They said, we didn't know we were being filmed, ergo you cannot use it against us. The Supreme Court said that the family could legally record what was happening in the resident's room, specifically because it was installed due to security concerns with respect to the resident. All right, so what problem does this bill try to solve? I think we forget about that sometimes, right? We kind of jump ahead. Facilities don't want hidden cameras in the rooms of residents because it can be used against them. That's what it comes down to. Especially when one of their residents is hurt or one of their residents dies due to the actions or inactions of the facility or its workers. I mean, it really is that simple. So who gets hurt if this bill passes? Well, our most vulnerable, our elders, our seniors, those who cannot speak for themselves or protect themselves, our mothers, fathers, grandparents, or to use the sponsor's language, tender and dear people in society. So I've heard that this is a consumer protection bill, that this will prevent bad actors who might abuse our loved ones. But the people that this bill purports to protect don't support it and don't want it. Y'all have heard from the AARP, the Alzheimer's Association. People have reached out to y'all. I know I've gotten tons of emails. And what this bill does is it takes away rights and protections currently afforded to our vulnerable Georgians. Namely, the elderly who many times cannot communicate to their family about abuse or neglect that may be taking place at the hand of their caregivers. Those with dementia, those with Alzheimer's. There is a reason you're in these nursing facilities. And this bill eliminates the ability of a family member who suspects an issue from finding out without alerting the wrongdoer. That's what you're doing. You're basically telling the wrongdoer, hey, we're going to put a camera out so we can watch you. So you might say, in terms of the choice we were given, it's either prevention or punishment after the fact. Well, that's a false choice. But so you might say, well, isn't that a good thing, right? If somebody would be deterred from abusing one of these residents because a camera was out in the open, because the abuser would know then that they could not escape detection. Well, the problem with that is that then the abuser knows exactly which residents can be victimized. Resident A has the big sign up, says, oh, better not come in here. We got video monitoring. So then you know anybody who doesn't have that up, they are fair game. So let's not talk about this about being consumer protection or actually deterring bad actors, because it ain't going to do that. The law can be a powerful tool for justice. The law should protect those that can't protect themselves. As written, this bill will do the opposite. We are taking rights away. Y'all think about that. We aren't giving rights. We're not protecting people. We are taking established rights away. The sponsor said this bill is about patients' rights. And it absolutely is. But it isn't about protecting them. It's about taking them away. Look, I'm on the side of our seniors and their families and making sure that they are protected when they cannot speak, they cannot bear witness. And that's why I don't support this bill. I will say I support the amendment because at least then, if there is video from a hidden camera, somebody actually may be able to be held to account for abuse and neglect. That does hurt our most vulnerable. I yield the well.
Chair recognizes the senator from the 52nd to speak to the measure.
Thank you, Mr. President. You know, on a lot of these issues, we have trial attorneys that are on one side or on the other of the issue, depending. I'm not up here as an attorney, but I am up here, I think, looking out for the patients. I've had scores of emails every day, and I haven't had one from any patient or from their family that says, protect me from that guy next door that may be filming me inappropriately. And there's laws against that anyway. I think we passed one from the minority whip to that effect tonight as well. They're saying, protect me from what may happen in this nursing home that they may not know about, or that they might not remember because they're an Alzheimer's patient, which is why the Alzheimer's Association, one of the reasons they're against this bill. And we heard the sponsor of the bill say, this still allows granny cams in there. They're still allowed, to a question that was asked. So if somebody was doing something inappropriate, illegally, it doesn't stop that. It still happens. It just protects the owners of this from any civil liability. And a lot of them say, you know, I'm worried about them turning the camera off on me, and what am I going to do when they turn it off, you know, and tell me, go to court and sue me or whatever. I don't think this is a good idea to take these cameras from being able to use for whatever evidence is there. None of the patients, not a single one, has asked for this. The provider organizations have, but not a single patient or family member has said, protect me from the guy next door to me. And this doesn't say whether it's a private room, semi-private room, anything like that. These people, it's their home. And we are taking away protection from some of the most vulnerable people we have. With that, I'll yield the will.
Any other senator wish to speak for or against the measure? Chair recognizes the senator from the 18th to close debate. Chair recognizes the senator from the 41st to speak to the measure.
Thank you, Mr. President. I just want to take a moment to try to break this down really clearly as it relates to the amendment. The amendment would allow these hidden cameras that are already permissible in the base of the bill to be used when something bad happens to a senior citizen, and it will allow them to use that footage to help make that senior citizen and that family whole. So let's be clear, when you only can use a film in a criminal case, then it's only criminal charges that will be brought up. That does not provide any restitution to the elder person who experienced the abuse or to the family. But when we open it up and allow for this footage to be used for civil cases, then a family can be made at least closer to whole. I mean, let's be honest. You really can't pay somebody enough when they've experienced abuse. But it gets them closer to being able to be made whole. So if we don't pass this amendment, what we do is say, we're okay with the CNA or the lowest tech on the totem pole. We're okay if she, and it's probably going to be a she, goes to jail. But we don't care about the fact that the facility hired her and may even know that she has repeated incidences of abuse. So this is what we do. We take away a family's right, an opportunity to be made whole, when we deny them the right to use this footage for civil and administrative suits. So I urge you to vote yes on the amendment and then on the bill. With that, I yield the floor.
Chair recognizes the senator from the 18th to close debate.
Thank you, Mr. President. Good evening, colleagues. I'll try to be short, but I need to address, quite frankly, several misstatements that have been made. We had some folks address this bill, and I appreciate the senator from the 25th and his compliments on bringing the bill. And I appreciate some of the other comments that were made as well. But with regard to the concern for Mama Flo, as we heard about in the discussion, who's concerned about someone getting in her liquor cabinet, she's still covered because it's a security issue. It's covered. I think there must have been a misunderstanding. Either I misspoke or maybe the senator hadn't read the bill. The cameras are not issued by the facility. The cameras are purchased by, put up by the family or by the resident. That's not something that the facility does. The problem is the amendment equals the Wild Wild West. It takes us right back to an area for these residents' homes in which hidden cameras can be anywhere and everywhere, even in rooms where multiple people live. And by its very definition of being a hidden camera, it means somebody in that room or multiple people in that room don't know it's in there. Now stop and think about that for a minute. It's a hidden camera. They don't know it's in there, but it's their home. It's where they live. And folks, this, as I told you in my opening comments, it's one choice or the other. There's not a middle ground for this. Either we're going to be about preventing abuse, or we're going to be about what the last senator who spoke about, money. You want to prevent abuse, or do you want this to be about money? The concern, or the statement that was made by the senator who first spoke said he didn't really see a reason for limiting a hidden camera. The problem is, folks, no one manages a hidden camera. It's there to capture whatever happens with whoever is there, regardless of how embarrassing or invasive it may be to somebody's privacy. This amendment equals no disincentive to use hidden cameras in a nursing home, which means an absolute de facto invasion of the privacy of those that don't know it's there. And there's no way around that. The senator from the 31st absolutely cut to the chase and asked the critical question that was better stated in the form of a question than anything I could have argued. When the question to the senator from the 25th was, would this amendment violate the roommate's rights? The senator deferred and said he'd have to get a legal opinion on that. Folks, you don't need a legal opinion for that. You need a little bit of common sense. Of course it violates the roommate's rights because they're being filmed and they don't know it. Of course it does. That's what this is about. It's about the respect and privacy of the other people that don't want to be privately surveilled. And so we've got to come up with some model, some sort of functional model that works inside these nursing homes, which, as I said in my opening, is a unique situation. It's not your home. It's not a hospital room. It's something in between, but it's where these folks live. It is their home. So yes, it absolutely would violate the roommate's privacy, and that is the point of all of this. This puts the idea of the value of a hidden camera above the rights of privacy of other people who are subjected to it but don't know that it's there. Cameras equal deterrence. Hidden cameras equal nothing but an after-the-fact documentation that may or may not be of some value. And I think the senator from the 11th probably stated it best when he said, you know, with regard to the comment from the 25th about a potential rape issue, cameras prevent the rape. The hidden camera just documents it. I appreciate the senator from the 6th concern and her reference to the Knuckles case, but please understand that all of the data that would have been on the Dempsey, that was the gentleman who was the subject of the Knuckles case, that was the patient's name, would still be admissible with this bill because that data is admissible in a criminal proceeding. It would still be there. And then I heard this from the senator from the 6th, and I think I've tried to write down the quote. The facility doesn't want cameras in the rooms because it can be used against them. It's just that simple. Let me give you that again. The facilities don't want cameras in the rooms because it can be used against them. It's just that simple. Read the bill. The bill allows for cameras in the rooms. Put them on the wall. It specifically gives the family and the resident the right to do that. Right now, we're in a state where the facilities aren't sure about what the state of the law is. Can they have a policy that says no cameras? Or do they have to have a policy that says only hidden cameras? That's what we've got to give some clarity on. With all due respect, the senator from the 6th says this bill takes folks' rights away. It does not. Read the bill, folks. It allows for cameras, and it allows and specifically provides for those cameras that do the greatest good, which is those that deter problems before they get there. This bill doesn't take away any established rights. It sets the terms, and that's what we're supposed to do. Because right now, it's the wild, wild west when everybody can put a camera no matter who's in the room or not. Finally, I'm about to close, and I know you're glad to hear that. We heard about all the people that are against this. You don't have any letters from people that are against this. What you do have are letters on your desk of multiple organizations, some of which are in the nursing home industry, and some of which have the specific responsibility for taking care of patients and elderly people that support this. They say there's a balanced approach to this. And then we have a letter that clarifies, in fact, some of the misinformation that y'all have been getting. So, Mr. President, as I conclude my remarks, we're really back to where we were to start with, which is we're on a continuum of do you want to be with this bill, which is all about prevention, or do you want to be at the other end of the spectrum, which is no to this bill, meaning that there will be no model, there will be no rules, it will be the wild, wild west, everybody's got a hidden camera, and Lord help the people that happen to be living in a room with someone or multiple roommates while they're being filmed in their most intimate times and they don't know about it. I would suggest to you that our folks deserve something better than that. These people that are not wanting to be filmed and are not even intended to be filmed ought to, in fact, have their own privacy. That's the choice you've got. Unfortunately, it's one or the other. I would ask you to vote for a policy that talks about and addresses preventing abuse. I'd ask you to vote no on the bill, vote no on the amendment, because what it does, what the amendment does is really gut the bill. Makes no difference. And we've provided no guidance to the nursing homes if in fact that's the case. So please vote no on the amendment and then vote yes on the bill. And let's give some structure to our folks out there. Thank you, Mr. President. I yield the well.
Senator has closed the debate. All right, first we're going to take up the amendment. Amendment by the senator of the 25th. The question is on the adoption of amendment number 1 by the senator from the 25th. All those in favor of the adoption of the amendment, is there objection to adoption of the amendment? There is objection. All those in favor of the amendment, vote yea. Opposed, nay. The secretary will unlock the machine. For what reason does the senator from the 41st rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that green is for granny?
I'm going to let each and every member make that decision on their own. Have all senators voted? Have all senators voted? Hallway clear. Mr. Secretary, please close the machine. On the adoption of amendment number 1, the yeas are 29, the nays are 21, and the amendment is adopted. All right, now we'll take up the measure. Questions on the adoption of the committee substitute as amended. Is there objection to adoption of the committee substitute as amended? Chair hears none. The committee substitute as amended is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, will you please close the machine? On the passage of the bill, the yeas are 49, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Did you find the budget? Chair recognizes the well-organized senator from the 19th.
Thank you, Mr. President. You've been keeping me very busy today.
Intentionally.
I would like to move that the Senate adopt the conference committee report to House Bill 81, the 2022 budget.
Mr. Secretary, can you please read the caption?
Committee of Conference report on House Bill 81. The Committee of Conference on House Bill 81 recommends that both the House of Representatives and the Senate recede from their positions and that the attached Committee of Conference substitute to House Bill 81 be adopted. Respectfully submitted, Senator Tillery of the 17th, Senator Miller of the 49th, and Senator Dugan of the 30th. This completes the order, Mr. President.
Chair recognizes the senator from the 19th to speak to his motion.
Thank you, Mr. President and members of the Senate. First, I need to, again, thank everyone who was involved in this process. What lies before you now is the conference committee report to House Bill 81, the 2022 budget. And this process would not have been possible without you, again, the subcommittee chairs who've worked so hard through the process, senators who brought their requests, and the Senate Budget Office. Again, I know we've done this one time already, but if y'all would give one more round of applause to Melody Debussy and the team over there. The conference committee report should look very similar to the budget that you saw come out of the Senate earlier this week. Appreciate your help with that. Roughly, I'd say 70 to 80% of the Senate positions were adopted. I'm going to run you through the big ones in just a minute, but I want to also let you know about a few other things that should have already been found on your desk. One is a letter dated today from Governor Kemp. Governor Kemp's letter lays out questions that he heard from this body specifically, asking about how federal funds would be applied and moved around in the 2022 budget and how it would be reflected for that time period and how we would be involved. So please take a look at that letter. It's specifically written to address the concerns that he heard out of this chamber, and I want to take a special second to thank Governor Kemp for hearing our concerns, addressing them, and for his work with OPB. I've said it before, but I want to say it one more time. There is no chance that this budget would have run this smoothly had Governor Kemp not opened Georgia up as early as he did. Our budget reflects the revenues of this state and the growth of this state because Governor Kemp took a bold move at that time to reopen Georgia. Another sheet you'll see we'll have for you later is just some talking points as you go back home into your districts you could look at, but let me run you through the highlights of the changes, just the changes. If you're looking at the Judicial Council budget, you'll see that the Senate adopted the Conference Committee adopted the Senate's position on the kinship care grants, which were important to this body. They also we adopted the House's position on the prosecuting attorney's position on funding for a prosecuting attorney's council. I apologize. We also adopted the House's position on Superior Court Judge, senior court judges, while they adopted our position on law clerks. The House moved to the Senate's position in the Conference Committee report on the Supreme Court budget, and we went to the House's budget on the Government Transparency and Campaign Finance Commission lines. In the Department of Agriculture, we did agree with the House and add back 1 soil scientist, 1 compliance specialist, and 2 vehicles pursuant to House Bill 1057, which again was something that was brought up in this chamber. And the House went to our line plus some for the Southwest Georgia project, which is a community food hub to bolster Southwest Georgia farmers. In the behavioral health lines, you'll see that we did agree early on, to about $40 million in ads from the House. The Conference Committee agreed to a $1.5 million ad for respite care services for rural communities, and also for a $100,000 ad for Rockdale Cares for respite services. In the budget for community affairs, you'll see that we adopted the House's position on the Regional Commission for Area Aging, and that the House adopted our position on preservation of historic sites and on the Community Outreach and Action Food Bank. The Department of Community Health budget is probably the area you'll see where the conference report changed the most. The House moved to the Senate's position on many of the changes there concerning skilled nursing facilities in Medicaid and in both areas of Medicaid. And also, the Conference Committee came up with a different number on the report for healthcare access for, sorry, let me back up for a second. We moved to the House's position for federally qualified health centers, whereas we went to a Conference Committee position adding back roughly $3 million on the rural health hospital stabilization grants. The House moved to our position on South Central primary care centers dental programs, which again was a priority and a position of this body. In the area of healthcare workforce, you'll see that we moved to a Conference Committee position on line 95.4 concerning funding for potential graduate medical education programs. Again, that was closer to the Senate's position. And we went to the House's position on funding young farmer positions in Fulton County, Pickens County, Ware County, and in Worth County. This budget also funds the LETS program, the Law Enforcement Teaching Students program, which I know is important to our Public Safety Subcommittee. And this budget also adopts the Senate position on a very important item to this body, funding for Senate Bill 48, which I know was championed by the senator from the 42nd, which completely funds mandated screening for state educational agencies for dyslexia specialists, which again this body supported and we've heard about in the halls for a while. The Conference Committee adopted a moderate position on testing, adding back a little bit of the ads there, and the Conference Committee took the Senate's position minus about $220,000 on funding the Office of Health Strategy and Coordination. The Conference Committee took the Senate's position on the Broken Shackle Ranch, as well as in funding court-appointed special advocates in Eccles, Henry, and Louds County, 3 counties that did not have that program. The Conference Committee also took the Senate's position on increasing funds to support community partnerships to stem learning loss due to the COVID-19 pandemic for K-12 students, and we look forward to the partnerships that we know are already developing with agencies there. The Conference Committee took the Senate's position on out-of-home care, and we look forward to that priority being met. It's $6.7 million, again, to fund therapeutic care for foster kids throughout our state. The Conference Committee also took a moderated position, but closer to the Senate's position on FODAC, Friends of Disabled Adults and Children, as well as the Senate's position on increasing funds for personnel for 2 safety fire educators. On the GBI budget, you'll see that the Conference Committee took the Senate's position on expanding a forensic pathology fellowship program with the Medical College of Georgia, and that the Conference Committee took the Senate's position on adding back a little bit of money for the Criminal Justice Coordinating Council for local grants that we had placed in our budget and was important to our Public Safety Subcommittee. The Conference Committee also took a number that was slightly higher than the Senate's number for increasing funds to provide a 2% increase for domestic violence shelters, and we backed off to the House's position to increase funds to fully fund 2 domestic violence shelters that had been partially funded in FY 2020. The Conference Committee took the Senate's position on increasing funds for sexual assault centers. In the Department of Labor, you'll see the Conference Committee took the Senate's position on fully funding the Chief Labor Officer position, We also added money in conference to create two new job classes to retain experienced sworn personnel in the Department of Natural Resources, and you'll see that position reflected in public safety several times. And we added $2.8 million to increase funds for state parks and outdoor recreational areas. In the Department of Public Health, the conference committee took the Senate's position to increase funds for Georgia Corps. It also took the Senate's position to increase funds for the Sickle Cell Foundation of Georgia, and we added additional funds to increase funds to support the Nurse Peer Assistance Program. In the Department of Public Safety, as I mentioned earlier, in the Department of Natural Resources, we had increased funds to create 2 new job classes to retain sworn personnel. We did that in the public safety budget, and you'll see that reflected on various lines. We also found a number that the House and Senate agreed to for increasing funds to fund a 75-person trooper school. On the DOT budget, or the Department of Transportation budget, the Senate receded to the House position on funds for the Athens-Clarke County Transit Project, as well as the Metropolitan Atlanta Rapid Transit Authority project at the Bankhead Station, and those will both be funded. We also increased funds for for the Freight and Logistics Plan in conjunction with the Georgia Commission on Freight and Logistics at $1 million, and added $500,000 in planning for one-time funds for a strategic development initiative for regional transportation on the I-75 corridor. In the Veterans budget, you'll see the Department of Veterans budget that we added $1 million to provide funds to create the Veterans Cemetery in Augusta, Richmond County, Georgia, pursuant to House Resolution 77. In the area of bonds, I'm just going to read the ones that did get funded in USG and TCSG, because I know that I see that you're already there. The Senate and House agreed, the Conference Committee agreed to fund the Georgia Southern University Jack and Ruth Ann Hill Convocation Center, to fund the purchase of equipment at the Convocation Center at Georgia State University, to fund design of the Gateway Building and infrastructure at Georgia Gwinnett College, to fund the Christenberry Fieldhouse renovations at Augusta University, to fund the construction of the Bandy Gymnasium renovations at Dalton State College, to fund planning, design, and construction at the Andrews Center renovation College of Coastal Georgia, to fund the MR&R bonds for our public library system, to fund libraries in the South Columbus Public Library Edition in Columbus, Muskogee County, Georgia, to fund the Thomas County Public Library in Thomasville, Georgia, and to fund the Gritters Library in Cobb County. We also added $1 million in conference to fund the design of the Cumming Academic Building and the addition to the Cumming campus at the University of North Georgia in Forsyth County, as well as funds for the Dr. Mark A. Ivester Center for Learning and Living at North Georgia Technical College. The Conference Committee also funded the Technical and Industrial Education Building at Southern Regional Technical College in Moultrie, as well as 3 commercial truck driving facilities and diesel technology programs at Georgia Piedmont Technical College, Atlanta Technical College, and Wiregrass Technical College in Coffee County. Mr. President, that's an overview of the highline items from the Conference Committee report. I appreciate the members of this body allowing me to be in this position and represent you on that Conference Committee, and I hope this is a budget that all of you can be proud of. Mr. President, if there are no questions, I'll yield the will.
You have a question. Chair recognizes the senator from the 42nd to your left.
Thank you, Mr. President. Does the chairman yield?
Yes, ma'am.
Thank you so much for your hard work on this, and thank you to our staff. We all appreciate it. I'm just hoping you can clear something up for me that occurred to me when I was reading Governor Kemp's letter. So it says that the governor does not believe that any of the state fiscal relief funds may be used to offset lost revenue. But in our case, it might appear that we will not actually have that revenue hole to be able to use it for that purpose. Am I reading that correctly?
You are, yes, ma'am. Because Governor Kemp took the proactive step, again, controversial at the time, to really reopen Georgia and reopen Georgia early, we've not seen the lost revenue that would trigger that portion of the American Recovery Plan.
So can I follow up on that,
Yes,
if
ma'am.
you'll yield? then I don't understand why we still have austerity cuts in the budget.
Oh, I'm so glad you asked that question. Thank you. And these are on my desk if you'd like for me to bring them, pass them out to you later. We've got the school system financials for all 180 school systems in Georgia and the amounts of money that they've received in federal funds, as well as what the reduction they received from austerity. And if you look at those numbers there, after this budget, the total amount of reduction in austerity would be roughly $382 million, whereas their total federal funds received during this time is $6,888,156,156,156,112. So the reduction of the 382 is, I won't say minuscule because dollars do matter. I understand that, but I would say pennies on the dollar to the federal ads.
Do you further yield?
Yes, ma'am.
Well, I understand that we have federal money coming in this year, and so I, don't necessarily agree, but I can see the logic, as you stated, behind retaining austerity cuts, even though I don't agree with it. But what about all the other departments that we cut back in June?
Yes, ma'am. We added back substantially in many of those areas, and you'll see that we took some of those reductions that may have been strategic at the time and spread those the monies that we were able to recover in those areas to other areas like the Department of Behavioral Health and to fund Senate Bill 48.
Right, so we had some other priorities, I understand that, but as I understand it, we still have decent number of departments that still have 10% cuts. Isn't that
Do
true?
you have anyone in specific? I'd be happy to go line
I
by line
thought
with you.
DBHDD still had cuts and a number of others.
Are you speaking before the $40 million that we've added back plus the $1 billion in federal funds?
I'm actually trying to talk about what we're doing with our budget. I do understand that there's a 1 year.
Could the senator please refrain using questions as it talks to the senator
Well,
in the well?
I was getting to the question, Mr. President. Thank you. So the question is the position that we do intend to continue austerity cuts because we're getting the one-time federal funding, so we don't believe that's relevant right now. Is that the answer?
I don't know that I accept the premise of it. What I would say, though, is I think that we've taken and used federal funds and state funds and pushed more state funds into the areas we thought were most necessary, including, I think you said behavioral health.
Thank you.
You have no more questions.
Thank you, Mr. President. I'd urge your favorable passage of the conference committee report, House Bill 81.
Does any other senator wish to speak for or against the motion? The chair sees none. Senator from the 19th has moved that the Senate adopt the conference committee report on House Bill 81. All those in favor vote yea, opposed nay. The secretary will unlock the machine. Have all senators voted? For what purpose does the majority leader rise?
Does green stand for getting to go home?
Let me check with the senator from the 41st. We get a thumbs up. Have all senators voted? Mr. Secretary, please close the machine. On the passage of the motion, the yeas are 52, the nays are 0, and the Senate has adopted the conference committee report on House Bill 81. I want to echo the senator from the 19th's comments on how appreciative we are of the Senate budget staff. Melody, thank you so much for what you do. Mr. Chairman, I want to thank you for what you've done for this chamber, too, and your hard work and dedication to this state budget. Chair recognizes the senator from the 56th for a motion.
Thank you, Mr. President. I move we remove House Bill 445 off the table.
Mr. Secretary, can you please read the caption?
House Bill 445 by Representative Spruce of the 61st and others. A bill to be entitled an act to amend an act to incorporate the city of South Fulton in Fulton County, Georgia, approved April 26, 2016, as amended so as to change the corporate boundaries of the municipality, to provide for related matters, to repeal conflicting laws, and for other purposes. The Senate Committee on State and Local Government Operations recommends that this bill do pass by substitute. Respectfully submitted, Senator Anderson of the 24th, Chairman. The Senate Committee on State and Local Governmental Operations offers the following substitute to House Bill 445. A bill to be entitled an act to amend an act to incorporate the city of South Fulton in Fulton County, Georgia, approved April 26, 2016, as amended so as to change the corporate boundaries of the municipality and for other purposes. This completes the order, Mr. President.
Senator from the 56 has asked for unanimous consent for House Bill 445 to be taken off the table. Is there objection? Chair hears none, and House Bill 445 is removed from the table. The chair recognizes the senator from the 56 to speak to the measure.
Thank you, Mr. President. Earlier today, we took this off the local consent calendar because there were some concerns and communication that needed to be addressed. I want to specifically thank the senator from the 39th, who unfortunately can't be with us, for her great work, as well as the delegations from the city of South Fulton, Fulton County, and the city of Atlanta. This will allow for some unincorporated areas to be moved into the city. This is a good bill, and I ask your favorable consideration. I yield the will.
Senator has yielded the well. Does any other senator wish to speak for or against House Bill 445? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? The chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. Secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 52, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 1st for a motion.
Thank you, Mr. President. I move that the Senate agree to the House amendment to the Senate amendment to House Bill 290 as amended by the Senate for Amendment 3.
For what purpose does the senator from the 11th rise?
Mr. President, I move to table House Bill 290.
That motion is not in order at this point. Mr. Secretary, will you please read the caption of House Bill 290?
House Bill 290 by Representative Setzler of the 35th and others. A bill to be entitled an act to amend Article 1 of Chapter 7 of Title 31 of the OCGA relating to regulation of hospitals and related institutions so as to prohibit hospitals and nursing homes from instituting any policy during a declared public health emergency that limits patients' ability to be visited by designated family members or friends as a condition precedent to obtaining or maintaining a permit to operate a hospital or nursing home and for other purposes. The Senate Committee on Health and Human Services recommends that this bill do pass by substitute. Respectfully submitted, Senator Watson of the 1st. The House offers the following amendment. Amend to the Senate substitute to House Bill 290 by striking lines 1 through 42 and inserting in lieu thereof the following. To amend Chapter 7 of Title 31 of the OCGA relating to regulation and construction of hospitals and other healthcare facilities and for other purposes. Senator Watson of the 1st offers the following Amendment 3 to amend the House amendment to the Senate substitute to House Bill 290 by adding after burn units on line 80 the following: psychiatric hospitals or units and for other purposes. This completes the order, Mr. President.
Chair recognizes the senator from the 11th.
Thank you, Mr. President. I again move that House Bill 290 be put on the table.
Senator from the 11th has moved that House Bill 290 be placed on the table. All those in favor of the motion signify vote yea, opposed nay. The Secretary will unlock the machine. This vote is to place House Bill 290 on the table, just for clarity. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the motion to place House Bill 290 on the table, the yeas are 42, the nays are 10, and House Bill 290 is placed on the table. Chair recognizes the senator from the 50 for a motion.
Thank you, Mr. President. I move that the Senate insist on our position on House Bill 409.
Mr. Secretary, can you please read the caption?
House Bill 409 by Representatives Gunter of the 8th and others. A bill to be entitled an act to amend Article 4 of Chapter 15 of Title 45 of the OCGA relating to counsel for public officials and agencies so as to provide for a process for state-funded representation of certain judges in legal action resulting from performance or non-performance of their official duties, to provide for a definition, to establish the Judicial Legal Defense Fund, and for other purposes. This completes the order, Mr. President.
Does the senator from the 50th wish to speak to his motion? He waives. The senator from the 50th has asked for the Senate to insist on our position for House Bill 409. Is there objection? The chair hears none, and the Senate has insisted on our position for House Bill 409. Chair recognizes the senator from the 50th for a motion.
Thank you, Mr. President. I move to remove House Bill 97 off the table.
Mr. Secretary, can you please read the caption of House Bill 97?
House Bill 97 by Representatives Leverett of the 33rd and others. A bill to be entitled an act to amend Article 2 of Chapter 9 of Title 15 of the OCGA relating to jurisdiction, power, and duty so as require and to provide for an oath for certain clerks of the probate court and for other purposes. The Senate Committee on Special Judiciary recommends that this bill do pass. Respectfully submitted, Senator Jordan of the 6th, Chairman. This completes the order, Mr. President.
Senator from the 50th has asked for House Bill 97 to be taken off the table. Is there objection? The chair hears none, and it's removed from the table. The chair recognizes the senator from the 50th to present the measure.
Thank you, Mr. President. I rise to bring House Bill 97. This is a bipartisan, easy bill. It passed unanimously in the House. Right now, if a probate court dies in office, there's not a succession plan. This requires that the clerk of the probate court take an oath prior to taking office so that he can succeed, he or she can succeed a probate judge in case of their peril. If there are no questions, I will yield the well and ask for your favorable.
You've done such a great job. Again, you have no questions. Does any other senator wish to speak for or against House Bill 97? The chair sees none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bills, the yeas are 46, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the distinguished Rules Chairman for a motion.
Mr. President, I would love to make a motion, but I think it's, oh, here we go. I ask to agree with the House position for House Bill 392.
Can we take it off the table first?
I move to take the House Bill 392 off the table.
That's better. Senator from the 53rd has asked that House Bill 392 be taken off the table. Mr. Secretary, can you please read the caption?
House Bill 392 by Representatives Ridley of the 6th and others. A bill to be entitled an act to amend Title III of the OCGA relating to alcoholic beverages so as to provide that licenses for retail sale of packages of alcoholic beverages for consumption off the premises shall be subject to regulation as to distances from schools as determined by the local governing authority and for other purposes. The Senate Committee on Rules recommends that this bill do pass by substitute. Respectfully submitted, Senator Mullis of the 53rd, Chairman. The Senate Committee on Rules offers the following substitute to House Bill 392. A bill to be entitled an act to amend Title III of the OCGA relating to alcoholic beverages so as to change certain provisions related to the sale of alcoholic beverages, to allow for local control as to the distance requirements for the sale of wine and malt beverages, and for other purposes. This completes the order, Mr. President.
After hearing the caption, it sounds like you may have gotten started on the law before it's passed. Senator from the 53rd has asked that House Bill 392 be taken off the table. Is there objection? Chair hears none, and it's taken off the table. The chair recognizes the Rules Chairman to present the measure.
Thank you, Mr. President. The change on this bill is this simple. It puts local control in. You know how local control is so important to us, unless it's not? Well, this time it is. This gives the local control to the just jurisdiction, the city, the county, or whatever jurisdiction it's in. And, Mr. President, that's all this does, the change. For alcohol, when it's regarding schools, is local control. I'd be glad to yield the well, but I'll answer any questions if there is any.
You have no question.
That's good.
Any other senator wish to speak for or against House Bill 392? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none, and the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? The Rules Chairman needs to vote for his own bill. Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 39, the nays are 8. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 3rd for a motion.
Mr. President, I ask for unanimous consent that House Bill 258 is taken from the table.
Ms. Secretary, can you please read the caption?
House Bill 258 by Representative Sands of the 180th and others. A bill to be entitled an act to amend Chapter 6 of Title 16 of the OCGA relating to sexual offenses so as to provide a response to State versus Williams 2020, GA Lexus 85, to provide that when a victim is under the age of 16, consent of a victim shall not be a defense to a prosecution for sodomy and for other purposes. The Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland of the 17th, Chairman. Senator Strickland of the 17th and others offers the following Amendment 1 to amend House Bill 258 by inserting between a code section and the period on lines 14 and 20 the following. Provided, however, that if at the time of the offense the alleged victim is at least 13 but less than 16 years of age, and the accused is 18 years of age or younger and no more than 48 months older than the alleged victim, this subsection shall not be applicable. This completes the order, Mr. President.
Senator from the 3rd has asked for House Bill 258 to be taken off the table. Is there objection? Chair hears none, and it's taken off the table. The chair recognizes the senator from the 3rd to present the measure.
Thank you, Mr. President. This is a great bipartisan bill. It passed the House with 0 nay votes. This bill concerns crimes committed against children. I can tell you there is no worse crime than one committed against a child, especially when the crime is sexual in nature. Our children rely on us to protect them from harm. This is a simple bill designed to close the loophole that the Georgia Supreme Court highlighted in State versus Williams. This bill will make it clear that a child victim under the age of 16 should not constitute a viable legal defense against charges of aggravated sexual assault and aggravated sexual battery. This bill will solve issues like the one seen in Georgia versus Williams, where the Court of Appeals reversed a conviction for aggravated sexual battery based on a child's victim capacity to consent. That victim was a 4-year-old child. This bill will close the loophole that almost allowed a child predator back on the streets. As a mother and grandmother, I believe it's our duty to protect our children from those sorts of despicable and deviant predators. There is also this bill from Senator from the 17th, and I would like for you to accept that also. Thank you.
Senator has yielded the well. The chair recognizes the senator from the 17th to speak to amendment number 1.
Thank you, Mr. President. As the senator from the 3rd was saying, there's an amendment on this bill. This bill went through, of course, both judiciary committees on each side, and we missed something, and we had a couple colleagues in the late hour from the 41st and from the a colleague from the 19th as well pointed out an issue. What the bill deals with is whether or not you have to prove as an element of sexual battery or aggravated sexual battery whether or not the child under the age of 16 actually consented. And we realized that in the current language we have, we did not include our Romeo and Juliet defense, as we call it in Georgia law. So what the amendment's going to do is say in these cases where an alleged victim is 13, 14, or 15, and the defendant is within 4 years of that age as well, that the state still must prove lack of consent at trial. That way it's not an automatic strict liability case. This is something that was signed off on by not just the defense bar, but also prosecuting attorneys council worked on us on this amendment. Happy to take any questions.
You have no questions.
I ask for your support of the bill and the amendment.
Any other senator wish to speak for or against House Bill 258 or the amendment? The chair sees none. All right, we'll take up Amendment number 1. The questions on the adoption of amendment number 1 by the senator from the 17th. Is there objection? The chair hears none, and amendment number 1 is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none, and the report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill as amended. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, will you please close the machine? On the passage of the bill, the yeas are 47, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed as amended. Chair recognizes the senator from the 51st for a motion. Chair recognizes the majority whip for a motion.
Thank you, Mr. President. I think I'd like to move that we take House Bill 477 off the table.
Ms. Secretary, can you please read the caption?
House Bill 477 by Representative Watson of the 172nd and others. A bill to be entitled an act to amend Code Section 48-7-29.12 of the OCGA relating to tax credit for qualified donation of real property, carryover credit, appraisals, transfer of credit, and penalties so as to extend the sunset date for applications for the tax credit for qualified donations of real property, to repeal conflicting laws, and for other purposes. The Senate Committee on Rules recommends that this bill do pass by substitute. Respectfully submitted, Senator Mullis of the 53rd. The Senate Committee on Rules offers the following substitute to House Bill 477. A bill to be entitled an act to amend Code Section 48-7-29.12 of the OCGA relating to tax credit for qualified donation of real property, carryover credit, appraisals, and for other purposes. This completes the order, Mr. President.
The majority whip has asked for House Bill 477 to be taken off the table. Is there objection? Chair hears none, and it's removed from the table. The chair recognizes the majority whip to present the measure.
Thank you, Mr. President. Senators, this is a bill that you've seen many times. This bill preserves land in Georgia, conservation measures that gives tax credits to those who want to preserve their real estate into perpetuity. This bill just extends the sunset to 2026, and it also puts a $20 million cap on it, which is lower than the previous bill that we passed 4 years ago. Mr. President, I'll yield the floor.
Senator has yielded the well. Does any other senator wish to speak for or against House Bill 477? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The Secretary will unlock the machine. Have all senators voted? Have all senators voted? Hallways clear. Mr. Secretary, will you please close the machine? On the passage of the bill, the yeas are 47, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 50th for a motion.
Thank you, Mr. President. I move that we remove House Bill 548 from the table.
Ms. Secretary, will you please read the caption?
House Bill 548 by Representative Dempsey of the 13th and others. A bill to be entitled an act to amend Code Section 49-5-41 of the OCGA relating to persons and agencies permitted to access to records so as to provide for reasonable access to records concerning report of child abuse to the administrative office of the courts and for other purposes. The Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland of the 17th, Chairman. This completes the order, Mr. President.
Senator from the 50th has asked for unanimous consent for House Bill 548 to be taken off the table. Is there objection? Chair hears none, and it's taken off the table. The chair recognizes the senator from the 50th to present the measure.
Thank you, Mr. President. I rise to present House Bill 548. This is a bill that will protect abused children throughout the state. It amends Code Section 49-5-41. It passed the House unanimously. And currently there are two separate and distinct systems that need to share pertinent information to protect abused children. And this bill would allow that to happen. And if there are no questions, I'll yield the well and ask for your favorable consideration of this bill.
You have no questions.
Thank you.
Does any other senator wish to speak for or against House Bill 548? The chair sees none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Mr. Secretary, will you please close the machine? On the passage of the bill, the yeas are 48, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. All right, we're going to move on to agrees and disagrees for a little while. Chair recognizes the senator from the 52nd for a motion.
Mr. President, I move that the Senate agree to the House substitute to Senate Bill 201.
Mr. Secretary, can you please read the caption?
Senate Bill 201 by Senator Hofstetler of the 52nd. A bill to be entitled an act to amend Article 2 of Chapter 2 of Title 48 of the OCGA relating to the administration of revenue and taxation so as to require financial institutions to provide certain information related to delinquent taxpayers to the Department of Revenue under certain conditions and for other purposes. The House offers the following substitute to Senate Bill 201. A bill to be entitled an act to amend Title 48 of the OCGA relating to revenue and taxation so as to require financial institutions to provide certain information related to delinquent taxpayers to the Department of Revenue under certain conditions and for other purposes. This completes the order, Mr. President.
Chair recognizes the senator from the 52nd to speak to his motion.
Thank you, Mr. President. This original bill that we did, 201, was a departmental bill that would let them use data analytics, informatics to obtain assets in a bank that had already been a judgment issued on and clearly go to the state. The House has added on a substitute section, and my understanding is everybody in the Fulton and Gwinnett County delegations, bipartisan, are in agreement with that says that their tax commissioners will not be able to increase fees simply to raise their salary. Apparently there was one that was trying to double their salary almost in the process. And so this is a request, again, bipartisan from those two county delegations to add this on, and I agreed to it. If there's no questions, I'll yield the well.
You have no questions. Does any other senator wish to speak for or against the motion? The chair sees none. The senator from the 52nd has moved that the Senate agree to the House substitute to Senate Bill 201. All those in favor vote yea, opposed nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the motion, the yeas are 47, the nays are 0, and the Senate has agreed to the House substitute to Senate Bill 201. Chair recognizes the senator from the 54th for a motion.
Yes, Mr. President, I move that the Senate agree to the House amendment, to the Senate amendment to House Bill 488.
Mr. Secretary, please read the caption.
House Bill 488 by Representative Scoggins of the 14th and others. A bill to be entitled an act to amend Title 15 of the OCGA relating to courts so as to provide for an increase in the minimum compensation for chief magistrates and for other purposes. The Senate Committee on State and Local Governmental Operations recommends that this bill do pass. Respectfully submitted, Senator Anderson of the 24th. The House offers the following amendment. Amend the Senate Floor Amendment 1 to House Bill 488 by striking the language contained within such amendment in its entirety. This completes the order, Mr. President.
Chair recognizes the senator from the 54th to speak to his motion.
Thank you, Mr. President. Friends, this morning we added an amendment to House Bill 488. And you know how it is, if you ask 4 different attorneys an opinion, you'll get 8 different answers. So this is the House's version. They would rather go back to the original language, and this is the magistrate court. The pay raises for magistrate judges across our state is too important of an issue for us to get hung up in legalese politics. So let's just go ahead and pass this out and go ahead and get our magistrate court judges the raises they deserve. Thank you, Mr. President. I'll yield the well.
Senator has yielded the well. To the point. Any other senator wish to speak for or against the motion? The chair sees none. The senator from the 54th has moved that the Senate agree to the House amendment to the Senate amendment to House Bill 488. All those in favor vote yea, opposed nay. The secretary will unlock the machine. Have all senators voted? Ms. Secretary, please close the machine. On the motion, the yeas are 48, the nays are 0, and the Senate has agreed to the House amendment to the Senate amendment to House Bill 488. Chair recognizes the senator from the 20th for a motion.
Thank you, Mr. President. I move that the Senate agree to the House substitute to SB 218 as amended by the Senate.
Ms. Secretary, please read the caption.
Senate Bill 218 by Senators Walker of the 20th and others. A bill to be entitled an act to amend Chapter 5 of Title 45 of the OCGA relating to vacation of office so as to provide for the suspension of compensation for certain public officers who are suspended because of an indictment for a felony and for other purposes. The House offers the following substitute to Senate Bill 218. A bill to be entitled an act to amend Article 1 of Chapter 18 of Title 15 of the OCGA relating to general provisions regarding prosecuting attorneys so as to create the Prosecuting Attorneys Oversight Commission and for other purposes.
These are just initials.
Senator Walker of the 20th offers the following Amendment 1 to amend the House substitute to Senate Bill 218 by inserting after members on line 23 who shall be subject to confirmation by the Senate by inserting after line 101 the following. The names of the appointees required by this code section shall be submitted by the appointing authorities to the Senate no later than the third Monday in January and for other purposes. This completes the order, Mr. President.
Chair recognizes the senator from the 20th to speak to his motion.
Thank you, Mr. President. You all passed overwhelmingly.
Hold on one second, Senator. I know the hour's late, but we still got a lot of work to do. If you could give your attention to the senator in the well, I would appreciate it. Thank you.
Thank you. This body passed overwhelmingly Senate Bill 218 a few weeks ago. It addresses situations where you have an indicted local official that is indicted for a felony and removed from office. It suspended their pay until the adjudication of their case. The House added to Senate Bill 218, basically House Bill 411, which establishes a prosecuting attorney's oversight commission to oversee district attorneys, just like similar to the Judicial Qualifying Commission does with judges. The Georgia Constitution, as you know, judges are part of the judicial branch. District attorneys are part of the executive branch. And the Georgia Constitution places the responsibility on Article 6, Section 8. Article 6, Section 8, Paragraph 2 of the Georgia Constitution says discipline, removal, and involuntary retirement of district attorneys. Any district attorney may be disciplined, removed, or involuntarily retired as provided by general law, which means the legislature. So we are the branch of government that is responsible for overseeing district attorneys, but we really don't have a mechanism by which to do that. And so House Bill 411 establishes that mechanism. It is two different panels. One is an investigative panel that would investigate a complaint against a district attorney, and then the other panel is the hearing panel that would decide whether those the case brought to them they would adjudicate that. So it allows for it. It spells out how these members are chosen. A 5-member investigative panel, and then a hearing panel. And so the House gets to appoint some, and the Senate gets to appoint some, the governor gets to appoint some. My amendment basically tries to take the House version that they put on 218 back to the Senate version that came out, which was LC 413161S. They had taken out the confirmation authority for the Senate. So the Amendment 1 gives us the Senate would have to confirm the appointees, and then there was a Scrivener's error, I guess you call it, on line 184, and it said judge, and it needed to say district attorney or solicitor general. I'd be happy to try to answer any questions. I know there are more learned people in the body that could answer questions about it better than I could, but if there are any questions, I'll try to answer them. If not, I will yield the well.
You've got some questions. Chair recognizes the senator from the 17th with a question.
Thank you, Mr. President. Senator Yield.
Yes, sir.
So to make sure I'm clear, now Section 1 of this bill is House Bill 411 that we voted on Monday, I guess it was, overwhelmingly to table. Is that correct?
I think I also voted to table it. Since then, I've studied the issue, and I think it's very good public policy.
Do you further yield?
Yes.
Isn't it true the only thing that's happened since then is they attached your bill to it, correct?
No, I agreed to this.
I
think it's very good public policy. I really do. I mean, otherwise, there's really no oversight for prosecuting attorneys currently, unless we want to have a bill in the General Assembly to deal with it individually, and I think this is a much better way to deal with it.
Do you further yield?
Yes, sir.
Isn't it true that one of the arguments we heard for tabling this bill was the fact that the Prosecuting Attorneys Council is currently working with the state bar to set up some new rulemaking ability where the state bar could oversee our district attorneys in a greater way? And if this bill does not pass right now, we could come back next year and get a report as to whether or not the state bar is now doing this versus creating a new state commission.
I guess you could argue that. It seems like it's kicking the can to me, and it's an issue before us now we ought to deal with.
Chair recognizes the senator from the 53rd for a question. He waves. Chair recognizes the senator from the 19th for a question.
Thank you, Mr. President. Does the senator yield?
Yes, sir.
Senator, is it not true that the only grounds for removal by this bill would be some of the following, including like mental or physical incapacity of a district attorney?
I'm sure you know of what you speak. Yes,
Is it
sir.
also true that another one might be willful misconduct while in office?
Yes, sir.
Is it also true that there might be one concerning? Thank you,
Easy.
Senator. Willful and persistent failure to perform the duties of one's job, including enforcing the laws of this state?
Yes, sir.
Is it not also true that another ground for removal under this bill would be the conviction of a crime involving something that the senator from the 53rd cares a lot about, moral turpitude?
Yeah, and I'm against moral turpitude myself.
Senator, would you further yield?
I've got a record of that, voting against that.
Senator, you further yield?
Yes, sir.
Senator, is it not also true that another ground for possible removal because of this bill would be conduct prejudicial to the administration of justice? Is that not true?
I'm sure you're right. Yes, sir.
Senator, of all those things I've mentioned, what can you tell me any of those reasons that would not be a reason to remove a district attorney should they be found to violate those?
You make a great point, Senator. Thank you.
Thank you, Senator.
You have more questions. Do you continue to yield?
I think I should yield the well, and maybe some of the attorneys in the body would want to come speak to it, or I don't know. But thank you. I'd appreciate your favorable consideration.
Chair recognizes the senator from the 19th to speak to the measure.
Oh, man. Thank you, Mr. President. So here's the deal. This bill allows a district attorney or a solicitor to be removed under certain situations. And those situations are spelled out and they're extremely clear. And it starts at line 146. Mental or physical incapacity, willful misconduct in office, willful and persistent failure to perform one's job duties which would include enforcing the laws of our state, conviction of a crime of moral turpitude, conviction or conduct prejudicial to the administration of justice, knowingly authorizing or permitting an assistant district attorney or assistant solicitor general to commit any act constituting grounds for removal under those things I just mentioned. That's the only way you get kicked out of office. If you're scared of this bill, I'm going to assume it's because you're doing one of those things. And if you're doing one of those things, then you probably don't need to be in office. Thank you, Mr. President. I yield the will.
Senator has yielded the well. Chair recognizes the minority whip to speak to the measure.
Thank you, Mr. President. I would also add that this bill also talks about the fact though, on page 8, that it says that it would not entertain these types of motions, based on charging decisions, plea offers, opposition to grant of a continuous placement on case on the trial calendar, unless that decision was done by various factors. And you'll see from 172 to on page 8 to 180. One of those factors which is very troubling is number F on page 8, which says a stated policy, written or otherwise, which demonstrates that the district attorney or solicitor general categorically refuses to prosecute any offense or offenses which he or she is required by law to prosecute. That goes exactly to the discretion that a prosecutor has. That's the whole key to prosecution. Prosecution is not about just automatically going forward and trying to place somebody in jail or put them on probation or suspend their driver's license. And so when you say categorically refuses, what does that mean? When you say a written policy or otherwise, what actually are we talking about there? It basically is discussing prosecutorial discretion. If you're a good prosecutor, that means you're weighing both sides to some extent. You actually have to look at what's in the best interest of the state. Sometimes it's not in the best interest of the state for a truck driver to lose his license and his family then to lose the only breadwinner that they have. Sometimes it's not in the best interest of the state, the whole state of Georgia, for somebody necessarily to get a felony marijuana, lose their Hope Scholarship, not able to graduate from college. Those are the things that prosecutors have to weigh. That one term, that one paragraph there, among many other paragraphs, is what is so troubling about this bill. It goes to discretion. It's totally different than when you start to talk about what we do with judges. That is when you start saying whether a judge is convicted of a crime. Of course, that's one thing. But we don't say, Judge, we're going to look at how you rule. That's not what we're looking at. This looks at prosecutorial discretion. A good prosecutor uses discretion. And what may look like somebody's not prosecuting the law is actually doing justice for the state of Georgia. And with that, I yield the well.
Senator has yielded the well. The chair recognizes the senator from the 6th to speak to the measure.
Thank you, Mr. President. I was sad that my good friend, the Appropriations Chair, wasn't going to take my questions. In terms of oversight with respect to district attorney, there actually are three ways that there is oversight. First, district attorneys are attorneys, right? They're members of the bar. So all those things that we're talking about in terms of mental incapacity, being convicted of a crime, guess what? You get disbarred. If you're disbarred, you can't be a district attorney. All right, check that off. Second is the Attorney General of this state is supposed to prosecute district attorneys when they are in dereliction of their duties. The fact that that may or may not have been happening does not mean that we should establish some kind of new oversight panel. Just may mean we need a new AG. Number three, and this is probably the most significant oversight for district attorneys, the voters. I yield the well.
Chair recognizes the senator from the 29th to speak to the measure.
You know, it's amazing the individuals that the district attorney practices in front of, Superior Court judges, they have oversight. My fellow colleague came up and spoke about the bar having oversight of district attorneys. The bar has not removed a district attorney from office in 15 years. I think it was a district attorney that mishandled a case down in South Georgia when a young man was murdered. I think it was a district attorney that mishandled a case here in Atlanta, Georgia, and arrested some law enforcement officers without due process, held a press conference the next day, and tainted the entire jury pool in Atlanta, Georgia. I think it was a district attorney that hid evidence in Savannah and required the state to pay over $3 million to wrongly convicted individuals. These are district attorneys. And amazingly, the voters didn't remove them, the bar didn't remove them, and the AG didn't remove them. And one advantage I have over anybody else that spoke is I'm not running for statewide office. Let me tell you what I'm doing. I want to protect the citizens of Georgia. That's what I want to do. And so when somebody is arrested for a felony, I want somebody in that office that is not corrupt, somebody in that office that is not bipartisan. I want somebody in that office that looks at every case the way they should be looked at and prosecute them accordingly. Now, Solicitor Generals are in here, and I'm blessed to have two of the best Solicitor Generals in two of my counties. I would take Suzanne Goddard in Muskogee County and place her against anybody, and I would take Ms. Taylor in Troup County and do the same thing. They handle over 1,000 cases a week. Understand this, we're not in here talking about district attorneys only. What we're talking about is thousands of Georgians who depend on them to do their job, protect victims of crimes. So I understand the senator did not oppose for the amendment to be made. I think he showed a lot of guts and courage to come up here and present a bill that he may not have been 100% comfortable with, but I promise you the justice system is nothing to find humorous, it's nothing to find laughable, and it is nothing to be flippant about. This is a serious, serious issue, and it is important that if we're willing to put oversight over Superior Court judges, if we're willing to put layers of oversight over every law enforcement officer that works in this state, if we put oversight over nurses, doctors, and everyone else who can lose their license to operate, then I think it's our responsibility to put one single serious piece of oversight when it comes to dealing with the individuals who have the capability of taking someone's freedom upon their word in an indictment. So please support this bill, and the senator from the 20th, Mr. President, I yield the well.
Senator has yielded the well. Chair recognizes the senator from the 31st to speak to the measure.
Thank you, Mr. President. So I'm going to be brief. I'm going to be quick. This bill, let's just cut to the chase. This bill basically came out of Paulding County, Georgia, from one of our House reps, because we've had a DA that's basically been missing in action for 2 years, not prosecuting cases, creating a backlog, and the taxpayers have been sitting back, waiting, while law enforcement are putting bad guys and bad ladies in jail, and nothing is happening. Now, I will argue that this has been going on. This bill maybe should have came long before, and I wish some of our elected leaders would have stood up and asked for this guy's resignation a long time ago. But the citizens of Paulding County have had enough, and if this is the way to get some sort of resolution to move forward so the taxpayer is not paying for this guy while he's not doing his job, while he's under indictment by the Attorney General, then we need to do this. So I'm here speaking on behalf of the bill for those in Paulding County, and hope you vote green. Thank you, Mr. President.
Any other senator wish to speak for or against the measure? The motion. For what purpose does the senator from the 50th rise?
Mr. President, I ask unanimous consent to be excused from voting on Senate Bill 218 pursuant to Senate Rule 5-1.8D.
Without objection, the senator from the 50th is excused from this vote. Would the senator from the 20th like to close debate? He waives. Senator from the 20th has moved that the Senate agree to the House substitute to Senate Bill 218 as amended by the Senate. All those in favor vote yea, opposed nay. The Secretary will unlock the machine. For what purpose does the senator from the 17th rise? He waives. What purpose does the Majority Whip rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, isn't it true that all those senators up there that are excused need to get back down to the Senate chamber quickly to vote for this bill?
The chair will be able to tell you better in about a minute. For what purpose does the senator from the 17th rise? You remembered your question.
No, I remember. Parliamentary inquiry.
State your inquiry.
Mr. President, is it true that if we vote red right now, we can actually then come back and make a motion to disagree to the House substitute for 218 and get our original bill back?
Gentleman speaks of great truth. Have all senators voted? All senators voted. Mr. Secretary, please close the machine. On the motion, the yeas are 24, the nays are 25, and the motion has failed to carry. For what purpose does the senator from the 20th rise?
Mr. President, I make a motion to disagree to the Senate version, the House version of this, SB 218.
The senator from the 20th has moved that this chamber disagree. Is there objection? The chair hears none, and the Senate has disagreed to the House substitute to Senate Bill 218 as amended by the Senate. Chair recognizes the minority whip for a motion.
Mr. President, I move to take HB 160 off of the table.
Mr. Secretary, can you please read the caption?
House Bill 160 by Representatives Body of the 62nd and others. A bill to be entitled an act to amend Article 4 of Chapter 8 of Title 48 of the OCGA relating to water and sewer projects and cost tax so as to redefine the term municipality and for other purposes. The Senate Committee on Finance recommends that this bill do pass by substitute. Respectfully submitted, Senator Huffsettler of the 52nd, Chairman. The Senate Committee on Finance offers the following substitute to House Bill 160. A bill to be entitled an act to amend Article 4 of Chapter 8 of Title 48 of the OCGA relating to water and sewer projects and cost tax so as to redefine the term municipality and for other purposes. This completes the order, Mr. President.
Senator from the 22nd has asked for unanimous consent for House Bill 160 to be taken off the table. Is there objection? The chair hears none, and it's taken off the table. The chair recognizes the minority whip to speak to House Bill 160.
Thank you, Mr. President. I rise today to talk about House Bill 160 for your favorable consideration. This actually would have been the senators from the 39th first bill. It is not mine, although I kind of feel like it because I'm taking her place, but it's still very important. This bill involves our friends in East Point, College Park, and Hateville, and to some extent also to Atlanta. In 2002, Atlanta requested and was granted a MOST tax to help improve its city sewer system. This system was improved and worked well. As this body will know, initially this referendum or this MOST tax was only going to be allowed to go forward 2 more times, or at least twice. It has worked so well that we've actually extended the ability for Atlanta to use the MOST tax over now 6 times. So that is great for Atlanta, tax dollars, government actually working. But here's this issue. You have the 3 cities that are mentioned that are actually interconnected with Atlanta's system. And this interconnection has caused problems. As the Senator from 39th has used as an example, said it's kind of like having a luxury SUV with a Volkswagen engine. It's going to run for some period of time, but at some point in time, you're going to have to put the right engine in there. And that's where we are with East Point, Hateville, and College Park. They have this interconnection, and they're going to need this most to actually be able to improve their sewer system. So this actually brings us to HB 160, which actually is very restrictive on purpose. One of the concerns about this bill has been that it would create a slippery slope and that other cities may do the same. The concern is legitimate, but not well-founded because the bill is so restrictive. This most would apply where there is an intergovernmental sewer system where there's over 85 million
Senator,
gallons.
could you stand at ease for
Thank
a
you.
moment? If you could give your undivided attention to the senator in the well, I'm certain you would expect the same. If you've got a conversation that has to happen, I'd ask you to take it outside the chamber. Proceed.
Thank you, Mr. President. This most would only apply where there's an interconnected system, where I believe in excess, where the system that you're connected to is 85 million gallons per day. And so that's the difference. I mean, this is purposely restrictive. And remember, this body actually this year actually did something where persons were concerned about a slippery slope. But where we had unique facts, we said that it was warranted because we didn't think that the slippery slope argument would actually apply. And that was with SB 9 and the circuit split bill between Columbia County and Richmond County. And I remember saying that at the time that although there was concern that those two counties were expediting the circuit split, I said that any other counties that could show that both of your major counties had requested this for over 20 years, that both of the major counties' elected officials had been requesting this, that both counties' elected bodies had said that they wanted to go forward, and it was the largest multi-county circuit in the state, then you had a slippery slope. Well, same thing here. If anyone can show that one city, which is the city of Atlanta, or any city, which they cannot because no other city has been approved for a most, under the circumstances that that approval was done, and that there are more than one interconnected city with them, and that because of that interconnection, one system is failing, and you're interconnected with a city that has over 85 million gallons of sewer waste, then therefore you would fit the slippery slope. We have unique circumstances here. So the argument that normally would be used cannot be used. And we've already seen earlier that when we have unique arguments, we step to the table and we actually make sure that we do the right thing. And also, let's don't forget, all we're doing is give the voters the opportunity to vote for this. That's it. They can still vote it down. SPLOST, things of that nature have been voted down before with other cities. Persons are going to be able to make their arguments for and against. All this does is give them an opportunity to meet their unique circumstances. And so with that, Mr. President, I would ask for a favorable vote on this particular bill, and I'll yield for a couple of questions if any has any.
Chair recognizes the senator from the 53rd to your left.
Thank you, Mr. President. Senator, you.
Yes.
I know you said this, but I didn't hear it quite clear. Isn't it true that this measure is only approved by the voters of that municipality?
That is correct.
And isn't it true that I support your effort?
Thank you. Yes.
You have no more questions.
Thank you. I yield the well.
Chair recognizes the majority whip to speak to the bill.
Thank you, Mr. President. I didn't know, ladies and gentlemen, this bill was coming up tonight, but I have a lot of concerns about it. Being a former county commissioner, being in local government for 8 years, and being in the Senate for the last 10 years, we've worked diligently with our local governments. And there's been a lot of compromise over the years over how they share their SPLOST and their LOST and their E-LOST taxes. And that's been done through a lot of compromise, working with GMA and ACCG to allow this most tax, municipal option sales tax, to go beyond the city of Atlanta would set a terrible precedent. This has not been done outside of Atlanta. The only reason the city of Atlanta has the most tax is because of a federal court order to repair their leaking sewer system years ago. we do not need to open this code section up to allow other cities to have this same tool. They currently get part of every SPLOST that's being levied in Georgia if and when they negotiate with their county. Cities will get a share of that SPLOST tax through their service delivery strategies. They negotiate where the sewer lines and the water lines go. Those revenues are shared by an intergovernmental agreement between the cities and the counties. It's done every year, and it's worked well. We do not need to break that open here tonight. I believe these 3 cities have some of the lowest water rates in the state. Water and sewer funds are considered enterprise funds. They should pay for themselves. When you sell water or sewer to your customers, you should generate enough money to pay for the cost to operate that system. They float bonds to pay for the expansion of those systems. They go to GFA and they borrow money at very low, very favorable interest rates. In fact, some of those loans are forgiven. Interest is forgiven, so it's zero cost and interest to those cities or counties. And they can use all these federal funds that are coming up. The majority whip or minority whip, I appreciate your friendship and I appreciate your passion trying to help these 3 cities. But quite honestly, they have plenty of tools in the toolbox already. To open this up tonight is just going to be the beginning. It's going to be like opening the floodgates for other cities to follow. And I can assure you there'll be others coming. The difference is cities under most will not have to share their revenues with the counties. That is not required in this bill, and it's not going to be required to be part of the referendum. In other words, they'll have their own sales tax that these cities will levy against every business and every consumer that shops in those municipalities, and they'll keep 100% of that money. Folks, I think this is a terrible idea. We should not do this tonight. We need to wait and let these cities work through the GFA boards. They need to look at federal funding that's coming from the federal funds that we've already heard. There's going to be over $5 billion coming to our local governments. Most of that money will be used for broadband, water, and sewer infrastructure. We've already heard that from the appropriations chairman. Let me just tell you that the last time College Park raised their water rates was 2012. The average water rate in those cities is roughly $30 per month. Now, if you live in a city or a county today and you have municipal water, your water bill is probably 3 or 4 times that in your communities. The cities have other choices and other options. They do not need this option tonight, and I ask you to not pass this legislation and we turn it back and we vote no. Thank you very much.
Senator has yielded the well. The chair recognizes the senator from the 33rd to speak to the measure.
Thank you, Mr. President, my fellow senators, colleagues, and the rest of y'all. I just want to encourage you to think about supporting this bill because it's a bill that the local people themselves want to make a decision on whether they want to work with this tax or not. So let's give the local people involved in this an opportunity to make that decision. And also it passed the smell test of moral turpitude from the senator from the 53rd. So keep that in mind when you vote for it. And I yield the well. Thank you.
Senator has yielded the well. Does any other senator wish to speak for or against House Bill 160? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. What purpose does the senator from the 51st rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, isn't it true there's over 535 cities in Georgia, and there's a possibility that every one of them will be back in the future to ask for the same provision, and we should vote red to kill this bill tonight?
Your numbers are correct, but the outcomes are up to each and every senator to decide on their own.
Thank you very much. Vote no.
For what purpose does the senator from the 22nd rise?
Parliamentary inquiry.
State your inquiry.
Is it not true, Mr. President, these are very unique circumstances and that these local citizens ought to have the right to at least vote to meet these unique circumstances?
The gentleman speaks with great passion. I'm sure he knows of what he speaks. Have all senators voted? Mr. Secretary, please close the... Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 35, the nays are 14. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, will you read a committee report, please?
Mr. President, the Senate Committee on State and Local Governmental Operations has had under consideration the following legislation and has instructed me to report the same back to the Senate with the following recommendation. House Bill 680, do pass. Respectfully submitted, Senator Anderson of the 24th, Chairman. This completes the order, Mr. President.
Chair recognizes the senator from the 42nd for a motion.
Thank you, Mr. President. I move that the Senate agree to the House substitute to SB 292.
Ms. Secretary, will you please read the caption?
Senate Bill 292 by Senator Parent of the 42nd, a bill to be entitled an act to provide a homestead exemption from City of Decatur Independent School District ad valorem taxes for educational purposes for 5 years in the amount of $200,000 of the assessed value of the homestead for residents of that school district who are between 65 and 69 years of age and whose income does not exceed $53,000, to provide for a homestead exemption and for other purposes. The House offers the following substitute to Senate Bill 292, a bill to be entitled an act to provide a homestead exemption from City of Decatur Independent School District ad valorem taxes for educational purposes for tax years 2022 and 2023 in the amount of $200,000 of the assessed value of the homestead for residents of that school district who are between 65 and 69 years of age and for other purposes. This completes the order, Mr. President.
Chair recognizes the senator from the 42nd to speak to her motion.
Thank you, Mr. President. This is a local bill for City of Decatur. The House simply adjusted the sunset from 5 years to 2 years, and I agree with that. So I'd ask for a favorable vote and agree on SB 292. Happy to answer any questions. And if there are none, I'll yield the well.
You have no questions.
Thank you, Mr. President. Thank you, colleagues.
Any other senator wish to speak for or against the motion? The chair sees none. The senator from the 42nd has moved that the Senate agree to the House substitute to Senate Bill 292. All those in favor vote yea, opposed nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, will you please close the machine? On the motion, the yeas are 50, the nays are 0, and the Senate has agreed to the House substitute to Senate Bill 292. Find him? Is he back? Oh, there he is. Chair recognizes the senator from the 11th for a motion.
Thank you, Mr. President. I move that the Senate agree to the House substitute to Senate Bill 305.
Ms. Secretary, can you please read the caption?
Senate Bill 305 by Senator Berg of the 11th, a bill to be entitled An Act to Provide a Homestead Exemption from Early County School District ad valorem taxes for educational purposes for the full amount of the assessed value of the homestead for residents of that school district who are 70 years of age or older and whose income, excluding certain retirement income, does not exceed $69,680, and for other purposes. The House offers the following substitute to Senate Bill 305. A bill to be entitled An Act to Provide a Homestead Exemption from Early County School District ad valorem taxes for educational purposes in the amount of $150,000 of the assessed value of the homestead for 5 years for residents of that school district who are 70 years of age or older, and for other purposes. This completes the order, Mr. President.
Chair recognizes the senator from the 11th to speak to the motion.
Thank you, Mr. President. This is a local bill that affects only Early County. It's a school tax bill, and I made an error. The version I sent over to the House did not have a 5-year sunset that we had agreed to, so Representative Green put that in for me, and we're just agreeing to this local school board tax matter. I appreciate your support. I yield the well.
Senator has yielded the well. Any other senators wish to speak for or against the motion? The chair sees none. Senator from the 11th has moved that the Senate agrees to the House substitute to Senate Bill 305. All those in favor vote yea, opposed nay. Secretary will unlock the machine. Have all senators voted? Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the motion, the yeas are 47, the nays are 0, and the Senate has agreed to the House substitute to Senate Bill 305. Chair recognizes the senator from the 32nd for a motion.
Thank you, Mr. President. I move that House Bill 591 be removed from the table.
Ms. Secretary, can you please read the caption?
House Bill 591 by Representative Hogan of the 179th and others. A bill to be entitled An Act to Amend Title 37 of the OCGA relating to mental health so as to authorize marriage and family therapists to perform certain acts which physicians, psychologists, and others are authorized to perform regarding emergency examinations of persons for involuntary evaluation and for other purposes. The Senate Committee on Rules recommends that this bill do pass by substitute. Respectfully submitted, Senator Mullis of the 53rd, Chairman. The Senate Committee on Rules offers the following substitute to House Bill 591, a bill to be entitled an act to amend Title 37 of the OCGA relating to mental health so as to authorize marriage and family therapists to perform certain acts which physicians, psychologists, and others are authorized to perform regarding emergency examinations and for other purposes. This completes the order, Mr. President.
Senator from the 32nd has asked for unanimous consent for House Bill 591 to be taken off the table. Is there objection? Chair hears none, and it's removed from the table. The chair recognizes the senator from the 32nd to present the measure.
Thank you, Mr. President. House Bill 591 came from a recommendation made in January by the Georgia Behavioral Health Reform and Innovation Commission, which was formed by this body in 2019. The bill adds licensed marriage and family therapists to the providers that can sign a 1013 or 2013 form, which is used to require psychiatric evaluation within 48 hours for people who are felt to present a substantial, imminent risk of physical harm to self or others. It also adds reporting requirements for the use of 1013s and 2013s issued by county, broken down by type of provider by the Department of Behavioral Health and Developmental Disabilities. It's no secret that we were already in a mental health crisis in our state even before the pandemic, and that access to trained mental health professionals is limited, especially in rural areas. Marriage and family therapists have the same licensing requirements as licensed professional counselors and clinical social workers and are licensed by the same board. The person would have to be seen by the provider within the previous 48 hours. This bipartisan bill will improve access to mental health specialists for people in crisis and hopefully prevent tragic outcomes by getting people the help they need. It will also provide us with useful data about the use of these forms. I'd be happy to answer any questions.
Chair recognizes the senator from the 17th with a question.
Does the senator yield?
Yes, sir.
Senator, did this bill come as a recommendation of the Georgia Behavioral Health and Reform Commission that we passed out, I think it was 2 years ago that we passed out this body?
Yes, this was so far their first recommendation.
Any further yield?
I sure do.
Can you tell us a little bit about the requirements as far as training and licensing for these marriage and family therapists versus the other type of people that are covered in the current law?
Yes, as you know, the other groups that have already been approved and have been in the law for several years are licensed professional counselors, licensed clinical social workers, and clinical nurse specialists in mental health. And the licensure requirements for this include a master's degree, practical internships, and additional years of postmaster's experience under clinical supervision and successful completion of a national license examination.
You further yield?
To my sweet mate.
Isn't it true that while Georgia has a serious mental health problem in our state, this is the first very small step that we can take to address this by supporting this recommendation from our Behavioral Health and Reform Commission?
The senator knows of what he speaks. I don't think anybody would argue about the mental health crisis that we have.
You have no more questions.
Thank you. I yield well.
Any other senator wish to speak for or against the measure? The chair sees none. The question's on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? The chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 35, the nays are 14. This bill, having received the requisite constitutional majority, is therefore passed by substitute. All right, we're going to take a 20-minute break. We're going to take a 20-minute break and catch our breath. We'll be back in 20 minutes. We will stand at ease.